August 1st shooting that occurred after the July 30th harmonized elections will resume today, with MDC President Nelson Chamisa expected to testify, reported Poloway 24. Chamisa and the rest of the opposition were warned repeatedly not to take part in the recent elections until democratic reforms had been implemented to make sure that the elections are free, fair, and credible. He would not listen, claiming, and I quote, MDC has stringent measures to stop ZANU-PF rigging the elections. The stringent measures did not work. ZEC, for Justice Chikumba and her fellow commissioners, blatantly disregarded the law to secure a landslide victory for ZANU-PF. Chamisa boasted that he had assembled an A-team to challenge the election result in the Constitutional Court. Judges went on to confirm Mnangagwa as the winner, ignoring all the evidence of serious disregard of the law under the pretext the evidence was not confirmed by the primary source evidence in the sealed ballot boxes. They, the judges, knew the plaintiff, Chamisa, had requested the ballot boxes to be opened, but the request was denied. Although the judges could and should have demanded to have the ballot boxes opened, particularly since they were the ones insisting on primary source evidence, they did not make any such demand because they knew the same chaos, irregularities, and illegalities, etc., found in the evidence before the court would also be found in the sealed ballot boxes. It is fair to say that the Constitutional Court started from the outcome. They had to confirm Mnangagwa as the winner. And so their task was to find a plausible excuse to justify their judgment. They would reject the damning evidence presented to the court by both the plaintiff and the key defendant, ZEC, on the grounds that it was not corroborated by the primary source evidence, a convenient legal bolt hole. It should be remembered that it was the same judiciary that had ruled the 15th November 2017 military coup was, I quote, legal, constitutional, and justified. Of course, it was naive to expect justice from a judiciary that is corrupt to the core. Of course, it was very foolish of Nelson Chamisa and all the other opposition parties to agree to take part in an election process they knew from the word go was flawed and illegal. But having agreed to a corrupt and incompetent ZEC organizing the elections, and to an equally corrupt and compromised Constitutional Court to judge the election process, it is naive of Chamisa to think he would now refuse to appear before the Commission of Inquiry into the August 1st shooting on the grounds that the Commission is biased. It would be a real surprise if the Montella Commission was not biased, corrupt, and incompetent. No one in their right mind expects the Commission to accomplish much other than gloss over the shooting, the serious matter of the rigged elections, which is what triggered the protests. But that is all besides the point. The point is that Chamisa accepted. The point is that Chamisa accepted the power and authority of the corrupt and compromised ZEC, Constitutional Court, etc., even after he had been warned repeatedly not to. It is nonsensical for him to now refuse to appear before the Commission when it is no worse than the other state institutions. He accepted some and he must accept all. No cherry picking.